Section 39 is about the performance bond. This is another important section. We have 6 clauses in total under these sections. For full statement, you may refer to PAM Contract 2018. Before discussing about the details in the PAM Contract, let us first understand what is performance bond. This is a mechanism of guarantee given by the contractor, where the employer can be used to safeguard in the case that the contractors do not fulfill his contractual obligations. And this is often in the modes of the monetary assurance. The purpose of this performance bond here is to ensure the contractors fulfill his contractual obligations to the employer. In the case that the contractors have some problem not being able to fulfill his obligations, the employer has the right to salvage the loss and expenses from the performance bond as given by the contractor. This is something which is compulsory to be undertaken by the contractor before entering the contract. Now, the amount for this performance bond is usually about 5% of the contract sum, and the contractors is not paying directly to the employer. This shall involve another third party, which is the bank. Contractor will liaise with the bank, prepare the performance bond, make known to the employer. In the case that the contractor fails to execute the contract or commit any breach of his obligations, this includes the contractor is unable to complete the work on time, whichever loss suffered by the employer can claim from the performance bond. How does the employer claim the performance bond? The employer will have to claim through the bank. This one just in case that the contractor is reluctant to pay the employer for the losses. These are some terminologies for the performance bond. Normally in the agreements of this performance bond, standard terminologies are used. The contract here is referring to the contract between the contractors and the employer for a construction project. Now, the employer here will be the party that issues and awards the tender. The contractor will be the party that bids and wins the tender. The guarantor will be the bank, and the word that is referring to, it will be the project that the contractor is undertaking. For a typical performance bond, the following details normally clearly stated: the contract number, which is the reference number, and also the dates, the project title, the contract sum, the performance bond sum, the expiry date, the terms and conditions, and also the parties involved. Simply said, when an employer issues a tender to a contractor will have to bid for the project. There will be quite a number of contractors trying to bid for the project. One of those contractors won the tender. Now the employer would like to form contract with the contractor. This contractor may or may not be the person known by the employer. Even the contractor is known by the employer, there is no guarantee that everything will go smoothly, as there are so many uncertainties. You know that the construction project is not talking about 1 or 2 ringgit. The money involved is rather huge. The implications of having something to go wrong, it may eventually translate it into a huge amount of money, which the employer dare not to risk for it. Now, since the contractor has been selected based on what he has bid for the price for the project, in order to safeguard the contractors fulfill all his obligations, a performance bond is introduced. This is nearly compulsory, and the amount of this performance bond will be equal to 5% of the contract sum. If everything goes smoothly, this amount shall go back to the contractor, and everyone is happy about it. But if there is any problem somewhere during the executions of the work, or when come to the closures of the work, something went wrong. As a result, the employer suffered loss, and it is fully due to the responsibility of the contractor. The contractor will have to bear with the consequences. As a result, the employer can claim the losses and expenses from the contractor. The problem now is, what if the contractor do not wish to pay the employer? There is nothing that the employer can hold over the contractor. This is where the performance bonds comes in. It is regardless that whether the contractor would like to pay to the employer, because now the performance bond is under the holding of the bank, which is the guarantor. When the employer is entitled to claim for the performance bond, the employer can claim directly from the bank. If with good justifications, the bank should release the fund to cover the loss and expenses suffered by the employer. This prevents the problem that the contractor do not wish to pay the employer when he himself breached his obligations. Now, knowing the functions of the performance bonds, let us look into the conditions and details in clause 39. First is about the submissions of the performance bond. Before the date of commencement of the work, the contractor shall submit to the employer a performance bond as a security for the due performance and observance by the contractors of his obligations under the contract up to practical completions of the work. It means that the contractor will have to get the performance bond before the commencement of the work, and this performance bond will need to be valid up to the completions of the work. Now, the amount for this performance bond shall be clearly stated in the appendix. Referring to the appendix, the amount of performance bonds are stated here. It is typically 5% of the contract sum. Next is about the validity of the performance bond. The performance bond will need to be valid until 3 months after the completion date. I believe this 3 months is due to the period of the delay, which is by default 3 months. Now you know that the validity of this performance bond, it will be starting from the date of the commencement of the work until completion date plus 3 months. This is by default, assuming now the project is completing on time. In the case that the work is not completed by the completion date, that means there is a delay of the work for whatever reason, whether the extension of time is given or the extension of time is not allowed, as long as the project haven't completed yet, the contractor will have to maintain the validity of the performance bond. With that, before the expiry of the performance bond, the contractor will have to extend the durations of the performance bond to expire 3 months after the projected practical completions of the work. The problem here now is the contractor cannot complete the work on time. Knowing now he cannot complete the work on time, after the initial completion date plus another 3 months, the performance bond is no longer valid. With that, the contractor will have to extend the durations before the expiry of the performance bond up to the new practical completion date, which is projected based on the work progress. Additional 3 months shall be added after the projected practical completions of the work. In the case that the contractors fail to extend the validity, the employer shall be entitled to withhold or deduct an amount equals to the performance bond from any payment due to the contractor. In another word, in the case of the delay of the work, that the contractor cannot finish the project on time and the contractor does not extend the performance bond, what's going to happen here, it will be the performance bond expired. Now in the case that the contractors do not fulfill his obligations, there is nothing to hold on to the contractor. Knowing now the contractor do not actually extend the durations of the performance bond, the employer can withhold or deduct any amount that is supposed to pay to the contractor during interim claim in order to salvage an equal amount for this performance bond. It is so that to ensure the mechanism to safeguard the employer still apply. Next, we talk about the payments from the performance bond. In the case that the employer determines the employment of the contractor, or in the case that there is a breach of contract, the employer may call on the performance bond and make payment out of it. You know that clause 25 here is related to the determinations of the employment of the contractor by the employer. That means the problem is with the contractor. Now the employer cannot tolerate with the default of the contractor and decided to stop the employment of the contractor. Or in the case of breach of the contract by the contractor, this is when the employer can call on for the performance bond. Now this performance bond here can be used by the employer for the completions of or ratifications of the work, especially when the contractor has been determined from the employment. The performance bond may be used to finance the pending works, and the employer may use the performance bond to reimburse the loss and also expenses suffered by the employer. This is when the problems come from the contractor, causing the employer to suffer loss and expenses. Then, on completion of the work, any balance of money remaining from the performance bond shall be refunded to the contractor without interest. This means that the employer cannot use the performance bond without any restriction. There must be good justifications of claiming for this performance bond. It is basically used to complete the pending works or to ratify the substandard work or ratify the damage and defect, and even to salvage the loss and expenses suffered by the employer. Now when there are balance from the performance bond, this shall be fully refunded back to the contractor without any interest. Now we talk about the returns of the performance bond. This one is related to clause 26, where the contractor determines his own employment. And when the contractor determines his own employment under the project, that means the problems come from the employer. Now when the troublemaker is the employer now, the employer shall not be entitled to claim any money from the performance bond. Now within 28 days from the determinations of the contractor's own employment, the employer will have to return the performance bond to the contractor for cancellations. Because of the determinations of the own employment of the contractor is no longer serving the employer. As a result, there is no point for this performance bond. There is no obligations of the contractor to the employer after the determinations of the employment. With that, the employer will have to fully refund the performance bond back to the contractor. This is about clause 39 on the performance bond. We have one more section here, which is the governing laws. This one is rather short. It says that the law governing the contract shall be the law of Malaysia. That means whatever being stated in the PAM contract shall not supersede the laws of Malaysia. Instead, the law of Malaysia is governing the law of the contract.